So today we're going to continue our readout of Team Karen Reed's recent appeal that was filed earlier this week to overturn Judge Beverly Cajones's recent ruling to dismiss counts 1 and 3 of the charges she was indicted. But before we get into that, I thought I would bring up something that I teased in my last video, and it has to do with our buddy, Mr. Michael Morrissey. Now, here's a name you may or may not recognize. If you are from Massachusetts, you probably have heard of the O'Connells. They're pretty notorious in the state, especially in the town of Quincy. So who is William Connell and what does he have to do with Michael Morrissey? Well, according to Lala3049, give him a follow if you are on the Twitter, it's X. William O'Connell built some of Quincy's most upscale properties, including the Marina Bay Complex and Granite Links Golf Club. But Michael Morrissey, in connection with William O'Connell, worked with O'Connell on development projects while he was a lawmaker on Beacon Hill. O'Connell has given thousands of dollars of Morrissey's campaigns over the years. Back in 2011, O'Connell was charged with 2 counts of aggravated R of a child under 16, 2 counts of paying a fee for R, and Coca-Cola trafficking, 18 grams of Coca-Cola. You're like that sugar rush, don't you, buddy? Prosecution charged O'Connell 73 with R over several months in 2009 when she was 14. In 2013, a special prosecutor and a lawyer for O'Connell presented a plea agreement to a Norfolk County Superior Court judge that requested to drop all charges against O'Connell, including 4 statutory R counts and a Coca-Cola trafficking charge. In exchange, O'Connell would plead guilty to the Coca-Cola possession, because again, he's got to drink his Coca-Cola, but not trafficking, even though more than 14 grams is considered trafficking, just like our friend shared here. So these are the people that Michael Morrissey associates with, right? And you can't tell me that he doesn't know. You can't tell me that he didn't know. Said it was not suitable to prove O'Connell was distributing it, even though that's exactly what the law says. But all right. So why was a plea deal offered? Because the then 14-year-old, now 16-year-old, this was back in 2013, was killed in a fiery car crash in a car that didn't belong to her. It was her and her friend, I believe, in Malden at 3:30 a.m. And investigators, of course, deemed there was no foul play. Now, there's not a lot of information about that specific incident. I don't know if it really was just kind of a odd coincidence, but I feel like it is kind of a weird timing. If it is a coincidence, it's a very bizarre coincidence because of this case that was going on. He's potentially facing all these charges for this exact thing that she had claimed in quite like description of just the horrific things that this poor girl suffered and was in fear of. And then she just happens to get unalived in a car crash in a car that didn't belong to her. Seems a little sus, but again, there's just not enough to really connect the dots there. So what happens? It meant that the statements she made to investigators about what happened with O'Connell couldn't be admitted as trial evidence. How freaking frustrating. And what case does this remind you of, folks? We covered it here on this channel. Charges were also dropped by the special prosecutor against Phyllis Capuano, I don't know why I can't say that last name, a 22-year-old, some Italian I am, from Everett, who was charged as O'Connell's co-conspirator in the initial alleged A against the minor. So that's really interesting. This is who Michael Morrissey is associating himself with. And I wonder how many other people, just like William O'Connell, were funding him, giving him thousands of dollars towards his campaign as essentially hush money. I mean, that's the way I would interpret it, allegedly. Morrissey got himself tangled in the case from the very beginning. It wasn't until the SJC stepped in that Morrissey had to appoint Berman to the case. So Andrew Berman was a special prosecutor that Morrissey handpicked because he was forced out of the case. The search warrant affidavit in the statutory R case contained explicit descriptions of encounters the alleged victim says she had with O'Connell. I mean, and not for nothing at this point, like there is DNA, there is R kits, is there not? So it would be fairly easy to prove whether or not she was lying. And from the reports I read, it seemed like she was very consistent, very much in fear for her life, very nervous, lived a life of anxiety right up until her death, which is just so sad because she lived such a short life. And I believe she was actually my age. So I can't, again, I always think about these things as, here I am living my life in 2011, 2013, essentially going through similar things back where I lived, which is crazy. And then just up north, this poor girl is going through these horrible things in this case and just living with all this anxiety every single day of her life, and then passes before she can even seek justice. I mean, it's just disgusting. So search warrant affidavit is a public court document. O'Connell's attorneys and the NCDAO fought to keep the document impounded until the trial, arguing its release would jeopardize the girl's willingness to testify and O'Connell's right to a fair trial, taint the jury pool. They also argued a district court judge abused his discretion in ordering the impoundment to be lifted. I mean, why is this not surprising, folks? And this is sad that this is the normal in Massachusetts. The SJC findings are attached in photo 1, but in short, the SJC said nope, just like Proctor, to the impoundment, and the search warrant and affidavit became public. So what they are referring to here, just again, because it's not just a sleuth that doesn't bring receipts, this is somebody who has back it up. And I can include all these links to all these articles. I'm not going to go into them all in today's video. I can, if you want me to do a separate video on this, we can do a mini one, maybe a members only. That would be fun, right? Gonna start pumping out members only content as well. But this is what they're referring to. The SJC unseals an affidavit, William O'Connell R case in Norfolk County, sought by newspaper. And this was in 2012. So when she passed just shortly thereafter in 2013. So jumping back. To the impoundment search warrant became public. Morrissey had to recuse himself, the irony, man, from that point, as his connection with O'Connell was shining bright upon the situation. And I have to say, more and more of this stuff is going to continue to get exposed. And again, props to Lala 3049 for doing this digging. I mean, these are all articles, right? Michael Morrissey is to lead by example. Yeah, so this is the photo that they are referring to. Just open it up in a separate tab. And then we'll get into the rest of the appeal from the Karen Reed appeal. So today, the SJC concluded that the state law keeping police reports of S crimes confidential does not apply to court records, especially affidavits prepared by police as they seek judicial approval for a search warrant. To adopt the proposal backed by O'Connell and prosecutors, Justice Fernande R.V. Duffley wrote for the court would impair the public's right to observe the criminal justice system. If applied to judicial records, such a requirement would have unacceptably far-reaching consequences. A wide range of court records in cases involving allegations of R or SA would be subject to mandatory and permanent impoundment. Regardless of the specific facts or circumstances of each case, Duffley wrote, the United States Supreme Court has emphatically rejected blanket prohibitions on public access to judicial proceedings. The SJC also said that O'Connell does go to trial. The judge in charge of his case has wide-ranging powers to assure potential jurors are not influenced by the news cover of the case and to take other steps considered necessary to protect O'Connell's Sixth Amendment fair trial rights. In the context of a criminal proceeding, the public's right of access, whether derived from the United States Constitution or common law, must be balanced against the defendant's constitutional right to a fair trial. Duffley wrote, judges are well equipped to safeguard a defendant's right to a fair trial. So that was that. And then I just wanted to, so these were some of the articles that were linked in the follow-up. So, and again, I mean, it's so wild. Like sometimes I feel like I'm starting to learn more about Massachusetts corruption than the own state I live in. Like that's a definite problem. I need to dig into more of my own local government as well. But Coakley supported Morrissey in keeping O'Connell's arrest warrant affidavit impounded. Now, who's Coakley? So this is the article I pulled up before. As I'm not actually showing you. This is the article I pulled up before. So again, shout out to Lala3049. Go give them a follow on Twitter X. The SJC unseals the affidavit. State's highest court today ordered an affidavit detailing a minor's allegations that she was ordered by Quincy developer William O'Connell at his residence at Quincy Bay Marina to be made public. In a unanimous ruling, the SJC backed a request by Quincy Patriot Ledger newspaper to unseal the search warrant affidavit filed in Quincy District Court by State Police Trooper Kathleen Prince last year as prosecutors investigated the R allegations against O'Connell. Documents were first sealed, but a district court judge later agreed with the newspaper, snaps for them, and ordered its release, prompting O'Connell and the special Norfolk prosecutor, Andrew Berman, on the case to ask the SJC to keep the record sealed. O'Connell argued his right to a fair trial was threatened by the disclosure, and prosecutors contended that record must be kept confidential under state law, making police reports on S crimes confidential, like we just read out. In a friend of the court brief filed with the SJC, Attorney General Martha Coakley. So again, this is, we're back in 2012, guys. I was in like 10th grade, I think, at this point. S crimes will not cooperate with law enforcement if they know details of the incident won't be made available for the public. So essentially they're saying, well, if they know it's going to get leaked out to the media, they're not going to cooperate, which I mean, I can firsthand say that's, for me personally, that's BS, because my whole thing was reported on like News 12. I remember being home from school after I went to the police station to give my statement, which was literally the most traumatic experience or one of my life, is sitting there having to talk about it in a room with a random person who I never met in my life and tell them what was happening, and then him telling me what they had found. It was wild. But it was all over News 12. It was all over News 12. They had posted articles from local media as well too, and nobody told me about any of it. I mean, I don't know if they contacted my parents at all, but yeah. So, I mean, and at the time, not to say that this doesn't happen, but the public does have a right to know, and you can totally, like I said, black out all of the stuff, like the specifics. Like, we don't need to know specifics, but just to know the basic details, the arrest, etc., where he was, who's he connected to, who else was involved. That's important information that the public deserves to know, because this is a predator that is perusing out on the streets and masking himself as this multi-million-dollar developer who could be working on a project with somebody's family, right? I mean, it's just disgusting. Concluded that the state law keeping police reports of S crimes confidential. Yeah, so we just read that. This was backed by O'Connell and prosecutors, which we just read, wrote for the court would impair the public's right to observe the criminal justice system, which again was really well said. Again, if applied to judicial records. So yeah, we read all that. The SJC also said we read that. Last September, O'Connell pleaded not guilty in Norfolk court to 12 charges. Including 4 counts of aggravated statutory R, 2 counts of engaging in unnatural acts and trafficking of Coca-Cola, and then he was free. He was put on cash bail for $150,000. Do you think for a developer, $150,000 is really going to make or break him? Absolutely not. Like, that is so disgusting. And I feel like anybody who's accused of anything as heinous as this, especially this statutory R of a minor, shouldn't be able to get bail. But that's my opinion, and I get it. Innocent until proven guilty, but like, I mean, it's just, I don't know. It's tricky waters there. Murky waters. Coakley's office appeared before the SJC to argue about the legal issues raised in the O'Connell case. O'Connell is being prosecuted by Special Prosecutor Andrew DiCarlo Berman at the request of Michael Morrissey to avoid a conflict of interest. No, the SJC was like, this ain't gonna look good, buddy. And he was like, okay, yeah, fine. Morrissey, and then, yeah, so he worked on developing projects with him, which again, like, developing projects, like, yikes. So, and just to show you the man behind the curtain, this is William O'Connell. So there you have it. So interesting, deep ties. And this is the Patriot Ledger, too. This was the Patriot Ledger, which was named the reason why the documents were ultimately able to be unsealed. But this reminds me so much of the Nikki McCain case, because of, like, even though she's a missing person still technically, they dropped the DV charges because she wasn't able to appear in court, and then they had the continuance, and then she wasn't able to obviously show up again because we don't know where Nikki McCain is. We don't know where she is, Tyler. Whenever you want to speak out, and I don't know. So there's that. Now I want to get back into the appeal. Reprosecution is independent barred because there was no manifest necessity to declare a mistrial on counts on which the jury was not deadlocked. Absent the defendant's consent, state and federal double jeopardy protections bar as a general rule retrial of a defendant whose initial trial ends without a conviction. Wright versus Commonwealth, quoting Washington, this rule is rooted in the importance to the defendant of being able once and for all to conclude her confrontation with society through the verdict of a tribunal she might believe to be favorably disposed to her fate. Cruz versus Commonwealth, quoting United States versus Jordan. See also Taylor. The double jeopardy clause affords a criminal defendant a valued right to have her trial completed by a particular tribunal. Oregon versus Kennedy. Thus, where a mistrial is entered without the defendant's request or consent, retrial is impermissible unless there was a manifest necessity for the mistrial, quoting United States versus Dinitz. So they're essentially saying because the defense didn't get a chance to say, yeah, okay, or like we object, or can we hear the split on this? Sorry, my cat's like going crazy with her jingle bells back there. Importantly, the heavy burden of establishing manifest necessity to justify a mistrial is exclusively on the Commonwealth. So they're saying this isn't up to us. This is up to the Commonwealth. This is the burden that they carry. This isn't our burden. We're not the ones with the burden. That's them. It's on them. Commonwealth versus Nickel. See also Commonwealth versus Stewart. And this burden remains solely upon the Commonwealth, regardless of whether or not a... Oh, I don't think I actually read this. Let's read this footnote. Commonwealth versus Di Benedetto, or Benedetto. The defense argument that the jury's verdict, which had just been announced in open court, was not, in fact, unanimous, depended upon juror testimony concerning internal deliberations, namely that they misunderstood the unanimity instruction. So essentially saying they didn't understand what the F Bev was talking about in those jury instructions. And it's interesting because, again, jumping back to Turtle Boy's interviews with these jurors, is that seemed to be a point of contention for them, is not understanding how to communicate what they deliberated, what their final verdict was on counts 1 and 3. And some of them wanted to pipe up and send a note to Bev. The foreman was like, no, I am the person to talk to Bev. None of you are worthy to talk to Bev. And we all have to reach a unanimous verdict on everything in order to contact her, because she's like this almighty freaking being, like totally untouchable, unreachable. I mean, but it's confusing. It's essentially what they're saying is it's confusing AF, and these instructions sucked. Which I know a lot of people are going to be like, but the defense agreed to them. And I'm like, it doesn't matter though, because I think at the end of the day, where the defense can really tighten up their case and is just really explaining what reasonable doubt is, and then Bev really explaining what needs to be unanimous, instead of just saying, you can't come back to me, and we played this in my last video, you can't come back with a verdict unless it's unanimous on all counts, which is not accurate. It's not truthful. It's very misleading. Di Benedetto also preceded this court's opinion in McCallum, and therefore must be disregarded to the extent the court perceives an inconsistency between the two. Defendant objects to the declaration of a mistrial. See Nickel, Commonwealth versus Horgan. Before a court declares a mistrial for manifest necessity, 1, counsel must have been given full opportunity to be heard. 2, the trial judge must have been given careful consideration to alternatives to a mistrial. See Taylor. Here, okay, cool. Before I recorded this, and I read 3 whole pages, and I realized that I was just reading it and it was only on me and not on the document. And I'm like, okay, let me just make sure before I continue reading so that I'm not all driving you nuts. Anyways, I digress. Here the defense respectfully submits the lack of opportunity to be heard alone is dispositive. Upon receiving the final jury note, the court declared a mistrial and excused the jury without consulting counsel. This action was sudden, brief, and unexpected, neither preceded nor accompanied by discussion with counsel. Oregon. See also Picard versus Commonwealth. Finding no manifest necessity where no opportunity was given counsel to argue the propriety of the question or the necessity of a mistrial. Stewart. Finding no manifest necessity where the trial judge first ruled that he was going to declare a mistrial, and then almost as an afterthought, unenthusiastically ask whether counsel objected. The defense was provided no opportunity to object to the declaration of a mistrial or to advise the court of the imperatives of Massachusetts R. Crim. Request that the jury be polled or discuss the issue with Miss Reed. I mean, yeah, it's like they didn't even get a chance to like explain to her, not that she probably needs an explanation because she's a very highly intelligent woman, but to explain, okay, this is what this means. Like, do we want, like, what do we want to do? Like, this is our timeout time where we get to kind of regroup and strategize for like 15 seconds. They didn't even get that. So that's essentially what they're saying. The defense respectfully submits that given the importance of double jeopardy protections and the profound implications of a retrial for a criminal defendant, an opportunity to be heard must, in order to be meaningful, occur after a reasonable opportunity for counsel to consult with their client. C.F. Gonzalez. Observing that some basic trial choices, including the choices to plead guilty, waive a jury, testify in her own behalf, or take appeal, are so important that an attorney must seek the client's consent in order to waive the right. So again, some basic trial choices, including the choices to plead guilty, waive a jury, testify in, hear her own behalf, or take an appeal, are so important that an attorney must seek the client's consent in order to waive the right. And it's interesting because in watching the Donna Adelson hearing from the other day, at the very end of the hearing, Judge Everett asked point blank, hey, is there going to be a plea deal that's offered? They asked the state, no, there's no deal. Defense, do you want to counter with your own offer? Donna said no. Okay, cool. And there was that. It's very transparent. It's very neutral. And that is the job of a judge, is to just be the referee. Be the referee. That's it. That's their freaking job. But no, Bev wants to teach and educate the jury on the law, right? Because she had some class. I'd be so curious, like, if anybody has taken, like, because I know she said that was like a scheduling problem with the initial hearing to schedule the other hearing for hearing oral arguments for the motion to dismiss. She had a conflict of like, oh, I'm teaching that night. I'm like, who are you teaching? And like, I'd be so curious, like, who's taking her class? And like, what is she like? I heard like actually like she's lovely in person, like to people. So I don't know. I don't know. Arguing that counsel had no opportunity to speak to Miss Reed. After all, it's her rights and theirs. Yeah. Counsel for Miss Reed clearly had no such opportunity here. So let's go to our footnote 5. Notably, the trial judge did ensure that Miss Reed was personally consulted regarding less weighty matters. For example, on May 24th, 2024, the court called Miss Reed to sidebar, personally asked her to verbally consent to AJJ's absent on the Tuesday following Memorial Day, and that co-counsel Attorney Inetti could represent her on that day. See May 24th, 2024 transcript. So this, and I pointed this out in my last video. You can go check it out. I'm not going to play it again. A lot of people on Twitter were like freaking out of like, what is this sealed like transcript about from May 24th? Because that was the same day that Higgins was testifying and has to do with something with Higgins because they went to sidebar after they were talking about what was said at the grand jury hearing and what Berkowitz had said to, I think, Higgins about how Brian Albert, how he was a little afraid of Brian Albert. And it was, cited right here as this is just them shining an example of here, you're asking for her consent, which was the right thing to do on something that's very minor, right? Something so little as like, hey, one of your attorneys isn't going to be available this day, so that later on you don't have to, if God forbid she is convicted and she wants to appeal her conviction, that she doesn't say it was because of ineffective counsel or anything like that, because he wasn't there that one day to cross-examine. So I like how they're using this. I know a lot of people have talked about this already, but I agree. I like how they called this out because it's something so small, but I think it's because it's like something so small, and what would seem like, okay, like this is just a standard thing, but it is important because it's like, well, here you're asking for her consent, but then we look at something that's a lot more serious and holds a lot more weight. Like, I don't know, the fact that her life is literally in the hands of these 12 jurors, and we want to know the best strategy, the best way we can represent our client going forward. So yeah, maybe knowing what the jury poll was would be helpful. And maybe they weren't going to ask for it anyways, but she has a right nonetheless to be consulted by her counsel about it. And they should be allowed the opportunity to object, which they were not. Whether or not the trial court was obligated to obtain Ms. Reed's personal consent. See Daniels versus Commonwealth. So then they just point out some case law to complement that. Its failure to at least ensure the counsel had an opportunity to consult with Ms. Reed on the issue undermines the existence of manifest necessity. It's very fun to say necessity. The record, I'm spiraling, it's like 11:30 here. The record is independently lacking on the second prong, as it reflects no careful consideration of alternatives to a mistrial. Here, there was one obvious alternative: to simply ask the jury to specify the charges on which it was deadlocked. And they very well could have said, for all we freaking knew, now we know what the split was, but for all we freaking knew, they could have been like, yeah, we were deadlocked and everything. It was 100% unanimous on the deadlock for every single charge, all three. And then we would have been like, all right, cool. Now we got to do this again. All right, whatever. So, but they didn't get the opportunity. So, the record is independently lacking on the second. Oh, I just read this. The option is apparent from the face of Mass R. Crim, which states that the judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the juries to return verdicts on those charges upon which the jury can agree, and direct that such verdicts have been received and recorded. In fact, the reporter's notes expressly indicate that such reception of partial verdicts is required before a mistrial may be declared for manifest necessity. This rule also provides that the court may declare a mistrial in cases where the jury is unable to reach a verdict, which applies directly to this case. However, it must first receive and record the verdicts which the jury can agree upon. Had the court inquired as to the existence of any partial verdicts and the jury articulated its verdict consistent with the statement of juror A, juror B, C, D, E, W, X, Y, and Z, the double jeopardy implications would have been clear and decisive. Indeed, with virtual, I don't know why I can never say this, unanimity. I'm having a day, guys. Unanimously, and cases have applied collateral estoppel to bar the government from relitigating a question of fact that was determined in defendant's favor by a partial verdict. U.S. versus Mespali. Yeah, I'm not even going to attempt to say that. You know what it says. Wallace versus Havener. When the jury hands down a partial verdict, a final judgment is rendered on the counts upon which the jury has reached an agreement. In denying the motion to dismiss, the court erred by relying primarily upon the lack of objection by defense counsel. Yeah, that's literally what she said in her denial. She was like, well, you didn't speak up, so that's your fault. Like, okay, Bev, just take no accountability whatsoever. Fine. That's cool. Cool. In doing so, it utterly neglected to acknowledge the clear and long-standing case law placing the burden of establishing manifest necessity squarely on the prosecution. And yeah, it's like at this point, they're like, we're not even blaming you. We are kind of blaming you, but we're blaming the prosecution. Nickel provides a helpful analog. The defendant Nickel was charged with operating a vehicle under the influence of alcohol. Only 6 jurors were impaneled, and after trial began, one juror recognized a witness and informed the trial judge that he might not be able to be impartial. The judge excused the juror. Left with 5 jurors, the judge and attorneys briefly discussed how to proceed. Defense counsel expressed his frustration over the impanelment of only 6 jurors and then stated, I don't think we can go forward with 5 jurors, can we? The judge responded, not in a criminal case. Okay, I'm going to declare a mistrial. After a retrial was scheduled, the defendant moved to dismiss on double jeopardy grounds. The trial judge allowed the motion, finding that contrary to his initial understanding, Massachusetts procedural rules would have allowed the trial to continue with 5 jurors, albeit with defendant's consent. The judge therefore found that he had failed to give careful consideration to the alternative proceeding with the trial before less than a full jury, and there had been no manifest necessity for the mistrial. So in that case, the judge was like, yeah, I made an oopsie, okay, bring out the dancing lobsters. On appeal, this court began from the premise that due to the importance of the double jeopardy protection, the Commonwealth bears the heavy burden of proving that a mistrial rested on manifest necessity. So yeah, what are you doing, Lowy? The court then agreed with the trial judge that the defendant could waive his right to a trial by a jury of at least 6. It rejected the Commonwealth's argument that the defendant in the case at hand had not provided such a waiver, observing, the question is not whether a defendant executed a valid waiver, but whether there was manifest necessity for declaring a mistrial. Such necessity would have presented itself if the defendant had declined to execute a waiver, but the record is clear that neither the judge nor counsel was aware or even considered the option. In these circumstances, the Commonwealth was unable to satisfy the heavy burden of proving that there was manifest necessity for declaring a mistrial. The defense respectfully submits that the same result is required here. So in this case, like they were saying, everybody took accountability. The judge, the Commonwealth was like, yeah, we effed up. We didn't consider other alternatives. This is what it is. But not here in Norfolk County. Well, not with this Commonwealth, at least. Not with Morrissey in the DA's seat. It is the prosecution's burden alone to ensure that the declaration of a mistrial is supported by manifest necessity, even where, unlike in the present case, defense counsel was expressly offered the opportunity to be heard on how to proceed and explicitly shared the judge's mistaken view that the trial could not continue with fewer than 6 jurors. This court held that the alternative to declaring a mistrial was not adequately considered. Here, there is no doubt that the court was permitted to accept a partial verdict, but the record simply reflects no consideration of that option. Accordingly, as in Nickel, the charges in this matter must be dismissed. So they're going for like full-on dismissal again. They're like, we ain't doing this. So we'll see. We'll see. Neither Miss Reed nor her counsel consented to the declaration of a mistrial. Consent may be implied where a defendant had the opportunity to object, but failed to do so. Pellegrin versus Commonwealth. But the law is clear that such consent may not be inferred from counsel's silence alone. See Commonwealth versus Edwards. Rejecting argument that the defendants consented to the declaration of a mistrial because he did not object when the judge ordered the case dismissed. Commonwealth versus Betsaya, holding that where the trial judge did not ask the defense counsel to comment on the possible declaration of a mistrial, the lack of an objection from the defense counsel cannot be construed as consent. So there you have it, folks. There you have it. Just because we didn't say anything doesn't mean that that is consent. I don't mean squat diddly. Here no such consent was sought nor was it given. Trials court reading that Miss Reed's counsel impliedly, oh my god, my vocabulary, guys. What does that mean, impliedly? I mean, I guess it just means implied. Hinted, yeah. Oh my god, I didn't even know implied had an adverb. I'm learning so much, like, just reading. This is what they should have kids do. And remember like those phonics books that you do in like elementary school? I feel like this would be so much more like the vocabulary books where you just learn basic words, nothing really that difficult. They should have kids in like 5th or 7th grade, like 5th, 6th, 7th grade, just reading court documents. Imagine how intelligent they would be. Holy smokes. Anyways, impliedly consented to, I'm going to use that in like every day. I don't know why. I'm just going to use it where I can. Consented to the mistrial was based primarily upon counsel's request for a Tui Rodriguez instruction. Of course, whether the jury has engaged in due and thorough deliberation to support a Tui Rodriguez and whether there is manifest necessity to declare a mistrial are distinct legal questions. In fact, the Tui Rodriguez charge is designed to urge the jury to reach a verdict, not avoid one. I love it. I love the snark. There's so much snark in here. Commonwealth versus Samido. Where did I miss the footnote? I guess that was from earlier? Or did we not get up to it yet? Oh, no, it's not. Okay, I thought we were doing this out of order, but we're not. We're good. Unsurprisingly, neither the Commonwealth nor the trial court cited any case findings a defendant's consent to a mistrial can be based on a prior request for a Tui Rodriguez charge. So now we're going to go to our lovely footnote. We got 7 pages, folks. In re, at 2-3, after the jury reported a deadlock, the judge indicated that he was inclined to declare a mistrial. The parties responded by requesting that the court give the Tui Rodriguez instruction as an alternative. The judge declined to give this instruction and declared a mistrial over the defendant's objection. In these circumstances where the request for a Tui Rodriguez charge came in response to a judge's statement of intent to declare a mistrial, it was a fair inference that both parties were provided an opportunity to be heard on possible alternatives to a mistrial. In the present case, by contract, the Tui Rodriguez was requested before any suggestion of a mistrial, not as a possible alternative thereto. Which I think is a really good point too, because they're essentially saying that nobody ever mentioned the word mistrial. And that is true. That is accurate. You can watch the whole trial unfold on the YouTubes. You can. So that was never once mentioned. And the fact that the Commonwealth wants to lean on, well, you know what the Tui Rodriguez instruction implies, but I like how they call it out with that little bit of snark of, well, usually it's meant to read it to urge the jurors to reach a verdict as like a Hail Mary pass, not to avoid a verdict. Whereas Lally was like, no, let's call it a day. Like, they're at an impasse. So the Commonwealth wanted a mistrial. But even there, no mention of the word mistrial was mentioned. Here, defense counsel's requests did not reflect any implicit concession that the jury was deadlocked on all counts, nor did they commit the defense to any position regarding whether the court should sua sponte declare a mistrial. It is true that if the jury reports an impasse after Tui Rodriguez, they shall not be sent out again without their own consent. That fact, however, does nothing to undermine the alternative of simply inquiring pursuant to a mass crim whether the jury had reached any partial verdict. Doing so would not require the jury to be sent out again. The trial court was in error in equating a request for a Tui Rodriguez charge with any acceptance of or acquiescence to a mistrial. Which I think, I like how they're laying all of this out. I really think they're making some really strong, valid points. Is anything going to come of this? I don't know. But I think this is probably a little bit more of a stronger argument than their motion to dismiss. But I think they're also kind of reacting based off of, which I like, Bev's denial of their motion to dismiss, the case law that the Commonwealth has quoted numerous times in their opposition, and what their oral argument essentially was fully contained here. So I like how they're hitting all of these different points. So they're not like, well, hey, wait a minute. But hey, wait a minute. But hey, wait a minute. They're like, no. Check this out. Check this case law out, Moreover, the trial court's characterization of the jury's final note as making it clear the jurors would not consent to continuing their deliberations is belied by case law cited in the court's order. In Commonwealth versus Jenkins, the jury simply reported after Tui Rodriguez that they felt strongly that there was no hope of progress and requested further instructions. I gotta stand now because my back hurts. What is it, kitty cat? I know. My cat is getting spicy. Hold on one second, guys. Yeah, this is my cat's time of night where she's like, aren't you done recording? Isn't it time to go to bed? Why are you still awake? And I'm like, because I had a lot to do today. That's why. So anyways, pets, man, right? Am I right? The court responded by telling the jury, I cannot force you to continue deliberations unless you agree to continue deliberations, but then asking them to retire and decide whether further deliberations on the next day would be fruitful. The jury promptly reached a verdict. This court held that the object of the statutory prohibition on sending the jury back out without consent was fulfilled because the jury consented to continue their work, which was similar again to the Ashley Benefield case, because I think they did have hey, we're deadlocked, and then they were like, do you want to go home tonight? And they were like, nah, we'll just keep working through it. And they reached a verdict within the first, I think it was only 6 hours of deliberation on that case. The jury's return of a verdict after sending their last note implicitly satisfied the statute requirement of jury consent, thus another alternative to a mistrial, which the trial court did not consider in this case would have been to A, inform the jury that it could not be required to continue deliberations without its consent, and ask it to retire to consider whether it was prepared to return any partial verdict. Here, neither Miss Reed nor her counsel were provided an opportunity to object to the declaration of a mistrial as opposed to the appropriateness of Tui Rodriguez. All of the cases cited by the trial court on this issue are readily distinguishable on that basis. For example, in Pellegrino, A witness testified at trial to incriminating evidence that had not been disclosed to the defense. This court held that the defense had an opportunity to object, given that the mistrial was declared after a voir dire of the witness and a colloquy after, I love that word, by the way, the colloquy, after the jury was cleared from the courtroom. Here, by contrast, the defense did not learn of the contents of the jury note, the court's intention to declare a mistrial, until the judge called the jury in and stated the declaration of a mistrial on the record. Counsel was never shown the note from the jury. The judge indisputably never informed counsel of its intent to declare a mistrial, much less solicited counsel's views on the matter. Defense counsel at one point implored the district court to declare a mistrial because the jury was deadlocked. It would be, I'm not even going to attempt to say that word, and wrong to allow parties freely to advocate on appeal positions diametrically opposite to the positions taken by those parties in trial court. United States versus you. Versus me? No, versus you. My dad joke of the day. After co-defendant moved for a mistrial, the court subsequently stated that it was going to declare one and asked the attorneys if either wished to make a record. United States versus Goldstein. Defendants had moved for a mistrial at a scant 2 hours before one was declared, at the first suggestion of a jury deadlock. And this one, I think they had like 2 or 3 of them. As the appeals court has explained in an analogous factual context, the suggestion that counsel could or should have immediately objected to the sua sponte declaration of a mistrial underestimates or ignores the difficulty of reaching a decision in which the defendant has an evident personal stake. Whether the defense would be advantaged or the opposite by a second trial, the possibilities ahead, such as the appearance of new prosecution witness, cannot be instantly calculated. Therefore, to equate silence with consent when the occasion comes abruptly and unexpectedly seems quite unwise. Oregon. Trial court's suggestion that the defense counsel had an opportunity to object to the declaration of a mistrial after it had occurred and the jury had been discharged is mistaken. The judge expressly told jurors, "Your service is complete." And again, I did this, takes off her glasses. I'm declaring a mistrial in the most dramatic way possible. Given counsel's lack of an opportunity to be heard and the court's lack of consideration of alternatives, the defense respectfully submits that the prosecution has not satisfied its high burden of establishing manifest necessity, which Lally kept pounding into our brains during his boring, horrific oral argument during the motion to dismiss hearing. While the trial court correctly observed that jury deadlock may be grounds for a mistrial, it cited no precedent for the counterintuitive proposition that a deadlock with respect to some but not all counts constitutes manifest necessity for the declaration of a mistrial as to all. Compare Fuentes versus Commonwealth. Affirming declaration of mistrial where note expressly stated that the jury could not reach a unanimous verdict as to either of the two indictments. This lack of precedential support is no accident. Such a rule would counter to the important interests underlying the constitutional safeguards against double jeopardy. Contrary to the trial court's suggestion, there was nothing in the jury's notes that directly contradicted the post-trial affidavits by counsel. As an initial matter, there is a facial tension between this observation by the court and its stated acceptance of the affidavits as true for purposes of the motion to dismiss. And the jury's reference to charges is easily reconciled with the post-trial affidavits affirming that the only deadlock related to the lesser-included offenses of count 2. Indeed, the court repeatedly referred to those lesser-included offenses as distinct charges, both in its initial and supplemental instructions to the jury. And they're going to show them the receipts. They got the receipts. In this context, the jury's note was facially susceptible to 2 alternative interpretations. Which again, this was like the whole, stink that Alan Jackson made about the verdict slip form, was the fact that it's confusing AF, Bev, and we need to clarify it because they could go checking all these boxes that they don't mean to check, or you're essentially guiding them to giving a verdict on a specific charge because it's confusing AF. In this context, the jury's note was facially susceptible to 2 alternative interpretations. 1, that the jury had reached an impasse to all charges, or 2, that the deadlock applied to only some of the charges on multiple lesser included allegations within a single count, such as count 2. The information received from jurors post-trial proves the latter interpretation was correct. So not that they reached an impasse on all charges, but that it only applied to some. And a lot of that, again, comes directly from not only the affidavits, but the interviews that Turtle Boy conducted recently as well. And I'm sure, honestly, they're not going to stop talking to the press. And I'm sure he's not the only journalist who's going to get jurors to come out. They'll probably start with him because it's a lot safer than going to a big major media news outlet for sure. I know I'd feel more comfortable going to an independent journalist than going to somebody like, NBC Boston or Boston 25 or whatever one Christina Rex is affiliated with. The jury's failure to expressly mention its agreement on counts 1 and 3 is understandable in light of the court's instruction that it should continue deliberating until it had reached a final verdict on each charge. And that, again, going back to the interviews with the jurors, that was something that the foreman kept reiterating is no, we have to reach a verdict on all charges. And, you can blame them all you want. And I don't like, if it is true, him telling them, well, no, you can't talk to the judge about what we really came to a conclusion on with counts 1 and 3. It's not his fault for misinterpreting the crappy instructions that she gave. It isn't. This court's holding in Commonwealth versus Roth that courts should not request partial verdicts on lesser included offenses charged in a single count does not pertain here. Roth was rooted in the belief that inquiry concerning partial verdicts on lesser included offenses that have not separately charged carries a significant potential for coercion. Also, in Bluford, declining to require a court to consider giving the jury new options for a verdict in the form of partial verdicts on lesser included offenses, where under Arkansas law, the jury's options were limited to 2, either convict on one of the offenses or acquit on all. Such inquiry, in effect, implies that the jury should consider conviction on the lesser count. No similar danger is present, whereas here, the jury was asked to return 3 separate verdicts on 3 separate counts. Exactly. See Roth, distinguishing situation where a defendant has been charged in separate indictments or complaints, each with a separate verdict slip. A juvenile, where a complaint or indictment in multiple counts charges multiple crimes, a general verdict could be returned as to one of the counts despite deadlock on the other counts. In this circumstance, when the jury reports a deadlock without specifying the counts on which it has reached an impasse, it is straightforward, and the defense contends constitutionally required follow-up to ask whether the deadlock relates to some as opposed to all counts. Contrary to the trial court's suggestion, an inquiry regarding whether the jury had reached a partial verdict on any of the 3 separately charged counts would not necessitate any forbidden inquiry on the lesser included offenses contained with count 2. There is simply nothing coercive about asking a jury reporting a deadlock that fails to specify which counts the deadlock relates to. The single question of whether its deadlock is on certain but not all counts, and if it has reached a unanimous verdict on any counts. I really like how this is written because it's like really easy to understand for the most part. Like some of the legal mumbo jumbo like sometimes goes over my head a little bit, but I really like how it's just simply but yet very eloquently put of, we don't care about anything else. We're not trying to coerce them into anything. And I like how they're using specific words that, again, was used in the oral argument as well, too, and their oppositions from the Commonwealth. Affirming trial judges' taking of partial verdicts on 2 or 4 of 4 separate indictments and observing to conclude that the jury could have felt pressure to convert provisional verdicts against the defendant into final ones, and to abandon all doubts that they may have privately entertained runs countered to the clear instructions of the judge and amounts to mere speculation without any support in the record. Roth. Noting in the context of a deadlock jury that Rule 27B permits taking verdicts on less than all charges set forth in separate indictments, Commonwealth versus LaFontaine. Affirming partial verdicts taken after the judge asked jury whether it had reached a verdict on any of the indictments, Commonwealth versus Garte. Very funny names in here. Holding that the judge's decision to take a partial verdict and encourage the jury to agree on the remaining charges was sound, where the jury indicated they were able to reach a consensus on some charges but not others. The inflexible prohibition on jury inquiry regarding partial verdicts advocated by the Commonwealth would inevitably undermine defendants' important and constitutionally protected interest in being, once and for all, to conclude their confrontations with society through the verdict of a tribunal they might believe to be favorably disposed to their fate, crews, and the danger of unfairness to the defendant from multiple prosecutions exists when a trial is aborted before it is completed, as well as when the defendant is actually acquitted. Washington. Commonwealth's proposed rule would also undoubtedly hinder law enforcement interests by precluding courts from asking whether a jury may have reached a guilty verdict on some but not all standalone counts. Oh my God, we're at the end, y'all. It is uncontroverted that, according to the jury of her peers following trial, Miss Reed was unanimously found not guilty of counts 1 and 3. That undisputed fact must not be lost in this analysis. It bears repeating that at the heart of this policy against double jeopardy is the concern that permitting the sovereign freely to subject the citizen to a second trial for the same offense would arm government with a potent instrument of oppression. Martin Lennon. Conclusion. Here we go, folks. For the foregoing reasons, Ms. Reed respectfully requests that this honorable court reverse the trial court and order that counts 1 and 3 must be dismissed. Mic drop. Mic drop. And Marty Weinberg signed it. So yeah, dated September 11th. I will I will add this to I'm going to stop scrolling so you stop getting dizzy. I'm going to include this document in the description box below so you can read it in full at your own leisure. It's 37 pages. We broke this up into 2 parts. So this is part 2. Part 1 was yesterday. And then we are shifting gears, folks, into a new case. We got the Donna Sue Adelson trial beginning next week. The jury selection is taking place on Tuesday, I believe at 8 a.m. Eastern. So I am going to do something daring and scary. Because I'll admit, I'm going to be real for a second. I am deathly afraid of live streaming. Not because I don't want to interact with you lovely people, because honestly, you guys are amazing and you've been so incredibly kind. For the most part, I know there's always going to be some stragglers out there that are going to throw rocks and whatever. They can go kick those rocks, but the majority of you guys are amazing and I want to have these conversations with you live. I'm just afraid of the technology part of it and navigating and switching back and forth, but I'm going to get over that fear because I want to do this with you. Also, why I haven't live streamed a lot of this is because, again, I have a day job. So Tuesday will not be the live stream, but I will do a video later that night where we'll go through what happened that day, any updates, etc. Business as usual. But when trial starts, opening statements, which I believe was projected for Thursday or Friday of next week, that will be live streamed. I don't have any phone calls that day with my client. As you guys know, I have a business that I also run during the daytime, and Tuesdays are my heavy call days. So I will not be available to do a live stream during working hours. But for the most part, the rest of the trial will be, except for Tuesdays, will be during normal business hours. And then I'll just have to flip-flop back and forth with work stuff, but we'll make it happen. We're going to do it. We're going to have fun. That being said, if you enjoyed today's video and you like the content, make sure you hit that subscribe button. Make sure you hit that notification bell so you don't miss the next update from me, whether it's Karen Reed or the Adelson case or something completely different. You never know here. I just kind of go with whatever is interesting and fascinating to me. And then I hope that we can have conversations about it here with you as well too. That's why I started this channel, is because I had nobody to talk true crime with, and now I have you guys. So this is amazing. And make sure you hit that like button because this is newsworthy news, and it tells the YouTube algorithm that it is newsworthy news. And the more people we reach with this story, the more pressure we are able to put on the DA's office to do the right thing. And with that being said, I will see you in the next video.